And crucially, decisions concerning validity and infringement will automatically take effect in all of the participating states. One decision on infringement, one decision on validity covers everywhere. So if someone invalidates your patent before the Unified Patent Court, goodbye, no patent. Whereas at the moment, it's eminently possible to have a decision that, say, the UK court finds the patent valid and a German court finds the patent invalid, which can be a useful bargaining tool. So, and I'm going to be, well, I'm talking about declarations of non-infringement. These will be heard in the Unified Patent Court Central Court, which will be set up in London, Paris, or Munich, and it's subject matter based. I'm a pharmaceutical patent attorney, and that's the Central Court will be in, the Central Division will be in London for that subject matter. So, that's a brief introduction, but it's not yet in place. There's various legal challenges and a certain degree of law that has to be written, and quite a lot of agreements for countries before this all coming into place. So I'm going to talk about some recent national court decisions which seem to be moving towards unification. The first one is Actavis versus Lilly, and the question here that the case addressed was whether the English court has jurisdiction over claim for declaration of non-infringement for both UK and non-UK designations of a European patent. A little bit of background, what was the case about? It concerned permetrexed, which is a drug for treating cancer. It's marketed by Lilly, and it's known as Alimta. This had a basic patent which has now expired, but the Lilly had also applied for supplementary patent certificates which expire in December 2015. A supplementary protection certificate is an additional right which extends beyond the lifetime of the pharmaceutical patent, but only covers the active ingredient. Clearly, we're talking about optimization and value. Lilly got their money's worth from that one. Lilly also owned a further patent, and I'm sure you've all heard the term evergreening, where you apply for additional patent protection, to extend your patent life term. The Lilly's additional patent, I'll call it the additional patent, expires in June 2021. So as you can see, nigh on 6 years beyond the supplementary protection certificate. And it is a medical use patent which claims use of permetrexed disodium with vitamin B12 for treatment of cancer. And that was granted. Now, Actavis, who are a generic, intended using a different salt, permetrexed dipotassium, after the SPC expiry. As I said, Lilly got their money's worth. Actavis never had any intention of entering the market before the original patent and its SPC expired. However, certainly at the time, there was a UK court jurisdiction that if you had a generic going onto a market and was about to launch a generic drug, they had to seek to clear the way of an existing patent. Otherwise, the courts would seem very likely to grant the patent holder an injunction to prevent them launching. You can clear the way by filing a declaration of non-infringement or by filing an invalidity suit. Actavis filed a declaration of non-infringement on 27th July 2012, and that date will become important, as you'll see later. Now, as well as applying for a declaration to cover the UK court, which is perfectly normal, they sought to have the decision apply also to the other national patents stemming from the European patent. Crucially, Actavis did not challenge validity, though we'll talk about validity a bit later, and Lilly contested the jurisdiction in as much as it covered the other national patents, not the UK. It's not a long decision, but it talks quite a lot about whether or not claims were rightly served and whether there was a dress for service. I'm going to set all that aside because it's not really relevant to what I want to talk about. And essentially, the the English court found that there were advantages in hearing the claim for declaration of non-infringement in respect to other EP states. There was clearly going to be a cost saving, and there would be a more consistent approach. It's going to be the same decision, the same outcome. And Lilly had argued that there would be many difficulties in applying foreign law because all the laws of the national states are applied differently. The court found that this outweighed those problems. So the court found that English courts do have jurisdiction for claims for declaration of non-infringement of both the UK and the foreign designations of the European patent. There was an appeal, and I think can be briefly summed up that the original decision was upheld, and at risk of repeating myself, English court has jurisdiction over a claim for declaration of non-infringement for UK and non-UK designations. But this only applies in certain situations. There must be no challenge to validity. Under EU law, infringement can only be heard in the court where the right is registered. The claim must be validly served, that's the claim for a declaration of non-infringement, and the patentee must be located in the UK or outside the European Union. But that's not the whole story. We're talking, the theme is international. Clearly this is only ever going to cover Europe, but there were other things going on at the same time. And I apologise for all the writing on this slide, but very quickly, Lilly started an action for threatened infringement of the German equivalent patent. And as you'll see from the date, they started that on 30th July 2013, which was just a tiny bit later, 3 days later, than the UK, than Actavis applied for the declaration of non-infringement. Just 3 days. Now, as we've seen, the English court believes it has jurisdiction regarding non-infringement because of the declaration for non-infringement. So under the Brussels regulation, the German court suspends the procedure of the German national patent until the decision of the English court. So the patentee has effectively been prevented from proceeding with proceedings for threatened infringement. That's still not the whole story, because the European patent had already been opposed at the EPO. They had filed an opposition. Now, the opposition had been rejected, but the appeal proceedings were still pending at the time. Now, because of the European Patent Convention, if there is an ongoing opposition or appeal proceedings on a patent and you are threatened or sued under that patent, then you are entitled to intervene in the opposition or appeal proceedings. So you intervene and you become a party just as if you'd opposed early on during the opposition deadline. So Actavis, or the German arm, are able to intervene in the appeal. And so, summing up briefly the very last point, here you've got infringement for all the designations of the European patent heard by one court, the English court, and the validity is heard for obviously the whole patent by the European Patent Office. So you've effectively, Actavis have bifurcated their proceedings. So what do we learn? What do we learn here? Well, the first point I want to make is clearly, national courts are now taking the view that they are fully entitled to make decisions for other national courts, and also that, depending on tactics used, as a patentee, you can be prevented from doing what you really, really want. Have I got time for a little bit? Have I got a little bit longer?
Yeah.
Fine, okay. So the second, and not dissimilar subject matter, I'm going to talk about the so-called Italian torpedo. This is, if you like, a tactic used by alleged infringers and or had been for some time. The Italian torpedo is what you do if you are threatened by infringement proceedings, you think infringement proceedings are going to happen. You apply for a declaration of non-infringement covering the Italian and the other national patents stemming from a European patent. You apply for that in the Italian court, and you apply for it to cover all designations. The Italian courts see this request, application for declaration of non-infringement, and they decide they have jurisdiction. For the same reasons as previously, the other national courts, for example, Germany, they stay their own infringement proceedings. Why would you do this? Well, the Italian court is perceived as being fairly slow. So by filing your declaration of non-infringement in Italy, the patentee has his ability to start infringement proceedings elsewhere has been stopped. He's been torpedoed. He's possibly been sunk, but he's certainly dead in the water. That's the Italian torpedo. And up to 2003, that was a fairly valid, I wouldn't say common, but it was a tactic that was fairly well known. Until the case on the second bullet point, where the Italian courts decided that they don't have jurisdiction over other national courts. So, sure, you could file for a declaration of non-infringement in Italy, but it wouldn't affect the German court proceedings and nothing else would be stayed. So it went out of fashion. As I said, the torpedoes run out of power. But as of last year, the torpedo is back under a clear and present danger, if I can quote Tom Clancy. This is a recent case, Massachusetts General Hospital versus Asclepion, and I don't have time to go into the whole decision because it's really very, very, very complicated, and I don't have Italian and only a partial translation of the decision. But essentially, they changed the interpretation of the relevant regulations and held that Italian courts, faced with declaration proceedings covering Italy and other designations, an Italian court does now have jurisdiction following this decision. So torpedoes are legitimate again. So, and I can sum this up in pretty much the same way as the first case. You've got a national court who is now increasingly willing to, or again willing, to make a decision that covers other national courts, or rather, not a decision that covers, but make a decision that has a bearing on other national courts, and also that a patentee can be prevented from exerting his rights, and I suppose you could argue his the value of his rights are perhaps reduced by these views and decisions of national courts. Now, this is, I wouldn't even say this is a trend. This is, a few decisions, but perhaps it points to the courts getting ready for the Unified Patent Court when that comes into effect, if it comes into effect. So that's the end of my talk. Thank you very much for listening.
Thank you, Mr. Phil.